You have to have an idea of what your case values might look like. We are here to help you and to help other people as well, and that we are trying to help as many people as we can. Our job is to represent individuals in a massive group. So you can't take all of the subjective issues into consideration.
Welcome to Trial Lawyer View, the podcast dedicated to the fierce yet compassionate lawyers who fight every day for justice in the courtroom. Our guests are top trial lawyers and their firms who share their stories and experiences, offering valuable insights into their journey, as well as expert guests who provide actionable strategies and practical tips for personal injury lawyers looking to optimize their operations, enhance client service, and drive growth in their practices. Trial Lawyer View is brought to you by Synergy. At Synergy, we aren't just a service provider. We are a strategic partner for personal injury law firms, seamlessly integrating with law firms to boost efficiency from day one. Outsourcing cumbersome administrative tasks like lien resolution and Medicare compliance to an expert partner like Synergy enables personal injury firms to focus on what they do best.
Welcome to another episode of Trial Lawyer Review, where I'm joined by Cameron Andrus, Mass Tort Department Manager at Balaban Associates. He is someone who knows the Mass Tort world from the inside out. With nearly 20 years of experience and thousands of client interviews under his belt, Cameron has mastered the art of guiding claimants through some of the largest and most complex litigation in the country. From designing high-performing intake systems to ensuring every client feels heard, supported, and prepared, Cameron blends compassionate mass tort management with precision-level efficiency. Raised in the mass tort arena under the mentorship of his father, trial lawyer Vance Andrus, Cameron has played a key role in high-stakes litigation, including working as part of the team which secured one of the highest national settlement values per client in a major mass tort. Whether it's building litigation from the ground up or streamlining client communication in massive dockets, Cameron is redefining how firms approach client acquisition, engagement, and resolution at scale. Cameron, welcome back to Trial Lawyer Review. Thank you for being with me today.
Hey, happy to be here again.
So last time around, we did an episode with your dad, and we went into kind of a real broad view of mass tort. And after that discussion, I thought it would be great to follow up with getting more into the nitty-gritty logistics of a mass tort from intake all the way through resolution. So with that in mind, I know you've done thousands of intake interviews in your career. What are the key strategies you found that are most effective for building trust with the potential mass tort clients during that first crucial conversation?
Thanks. That's a good question. So the way that we build trust and communication with our clients that I've learned over my years is I set realistic expectations from the beginning. I've found is when I tell a client, you're getting into this, but it doesn't go fast. And so we explain to them some of the steps that go into pursuing their claim. We've got to do discovery for you. We've got to do discovery for the defense. There's going to be millions of pages involved in that. There's going to be, dozens of experts. There's going to be hundreds of thousands of pages of reports from experts, so on and so forth. Just really setting a baseline that then when you follow up and you say to the client, it is likely that this case is going to take between 5 to 10 years, with the average being 7. That the client has some understanding of what the reasoning for that is. And then you can also follow that up with, everybody, I mentioned this last time, everybody thinks that their case is worth $1 million. Explaining to the client from the very beginning that there's too many people, there's not enough money, that's not going to happen, but we are going to do everything that we can to help you. So that's sort of a initial conversation, and then quick follow-ups with them. When you first get that client in the door, I want to talk to them once every couple of weeks until we've got some medical records and until we've built a level of communication with them. And then I extend out how long between each communication with the client. And I do that also by explaining to the client that, we've had a lot of communication up to this point, but we have the information that we need. We don't need you to get frustrated by every time that you talk to us being told the same thing over and over again. You don't want to hear that we're no further along, that we haven't filed your case yet because it's not time to file your case yet. You don't want to hear that even once we have filed your case that there's so again, that trust building comes back to communication. It comes back to treating them like a human being. Actually, today I was explaining to some of my staff the idea that everyone is a specialist at something, right? And your clients have hired you to be a specialist at this, but everybody's a specialist at something, whether it's hammering in a nail or building a moon lander, right? It takes a specialist to do that. And so while your client may not be a specialist in this, they want to have someone who can and who will help them through it.
I recently had a guest on the podcast that talked about in the mass tort space, this challenge with dual rep. And I'm curious if some of and part of what his jumping off point on that was how critical it is to have that communication line today more than ever because of what can happen, particularly in mass tort. And so I'm curious if that's part of what you're doing is cultivating that relationship so that there's no confusion about, who's representing this particular claimant.
Sure. Yes and no. So in terms of yes, I find it very important to communicate with your clients to make sure that they know there's always somebody marketing. There's always somebody looking, and these clients, especially when you're dealing with cancer cases, tend to have poor memories. They don't remember who their lawyer is. They don't remember their name. And then you put a face in front of them. And they go, oh, that must be my lawyer. And they call that number. And next thing you know, they've signed a second contract. Personally, I don't find dual rep to be an intentional action by most clients. The vast majority of dual rep clients are accidental actions where they sign up with a second firm. When it becomes intentional is when they've signed up with 5 or 6 or 7 different firms. And at that point, I basically just bow out. I say, it's not worth chasing you. You're not trustworthy. And that's something that not just we as a firm need to build. It's something that our clients need to build with us. You have to be able to trust your clients and your clients have to be able to trust you. And if you can't trust your clients, what's the point? You're never going to get an honest answer out of them. So,
yeah, good point. So today, with how there are aggregators of potential claimants, I'm curious because the client acquisition process can be a little bit more complex. How do you guys balance what needs to happen in terms of vetting of potential claimants with speed and efficiency in your processes?
Sure. That in my mind starts with, again, hiring a specialist. Everything to me is about hiring a specialist, whether it's from the time that I hire a marketer to the client hiring my firm to help them, to hiring a good lien resolution company that's going to take care of and make sure that your client is treated properly, right? These things are specialties. You don't, I say this all the time. You don't hire a plumber to do your carpentry. So when I talk about hiring a good marketer to help me advertise to our clients, I don't want to hire someone who comes across as a used car salesman, who tells me everything that I want to hear. I want someone who's going to be honest with me and is going to say, hey, here's what our process is. Here's where you can see on the back end how much of your money we're spending. Here's where you can see what advertisements we're putting out. I don't need to okay everything. but I want to be able to see what you're doing. The last thing that I want to have is, which I've had happen in the past, is clients telling me, I never said that. What do you mean you never said that? Right? Because we vet even once the marketing firm finds them, sends them to us. We then vet those questionnaires that company has put together. And I won't name any names, but I had a company one time that we collected over 700 cases from, and I had hundreds of people telling me that they never said what was on their questionnaires. I called the company. I said, give me the recordings. They didn't give me the recordings. I continued to harass them about the recordings. They continued to say that they want to give me the recordings. And then after 6 months, I finally got somebody, at the top. He said, all the recordings have been deleted. We don't have any of those. That's a used car salesman, right? And that's the kind of person who says, when you show back up with the lemon that they sold you, well, that's not my problem. It's your lemon now. It's not my lemon. So when I think about a company, I think about someone who I'm going to take to my hunt camp with me, right? Someone who's going to be my friend and someone who I know that I could trust, and that's just it. You take the time, vet, we have to vet our clients, but you have to vet the people that you're hiring to get your clients first.
Great point. Well, I think it goes really towards all vendors. That's part of what we talk about in terms of beginning stages of relationships with our clients is, hey, it's a partnership. We want to work in partnership with your team to make sure we get the right result for your client, the injured party. But what you're talking about, that's such an important point, especially in the world that we are involved with because of what's happened to that person. It's, probably the most traumatic thing that's ever happened in their lives. So very important.
Exactly. The idea that we represent people who, at their most vulnerable, were taken advantage of by a corporation, right? It is our responsibility to be better than those corporations. It is beyond our ethical duty. It is our moral duty. And I spoke about this before. Ethics and morals are important. What we are ethically required to do by the law is not necessarily what we are morally required to do as human beings. And I take the moral standard of when I say I'm going to do something, I do that thing. When I tell a client that I'm going to do my best to take care of them, I do my best to take care of them. And I hire good vendors and I associate with good people, which you yourself just pointed out. You associate with good people and good things happen. You associate with bad people and bad things happen.
The importance of values too, right? That's what we really push throughout our organization is our values, which is professionalism, respect, integrity, dedication, empathy. Because we want everybody that's working on our team to buy into that because of the importance of the work they ultimately do and who they are delivering for. Great points. And ultimately, I think sometimes gets a bit pushed to the side in some of the hustle and bustle of this world. But it really is, when you get right down to it, who you're serving, such an important thing to consider when you're vetting vendors. So during the last podcast, you talked about the importance of communication. And I'm curious about what systems you guys have found most effective in keeping clients informed and engaged during what is oftentimes, as you described, a long journey with a mass tort.
Sure. I may have said before, and I'll say it again. Just because your client is ignorant of what we do does not make them an ignorant person. The idea that, well, they won't understand what we're doing, so we're not going to tell them. I don't want to use the word insulting. That's not right. It's somewhat confusing for the client, right? They want to have a general idea. Well, obviously, you don't have to tell them the specifics. You don't have to explain, a judge is ruling on a 30B6 motion, so on and so forth. But you explain that, hey, we're in the discovery process. And here's some of the steps that go into the discovery process. And I've written up a list of like 27 steps that I send out to clients when they really want to know. Here's 27 steps that happen in every case to help you understand what we're going through. And that includes explaining discovery, explaining PPFs, explaining the PFS process, explaining why it takes so long for a case to get in front of, for a trial to occur, right? And just explaining all these steps. The sort of communication that I use and the processes that I use to communicate this with our clients is we tell them, first off, we're going to call you on the phone at least every 90 days throughout the entire process. For 7 years, at least every 90 days, you're going to get a phone call. Now, that's only 28 phone calls per person, if you look at it in those terms, right? Obviously, it ends up being some more because sometimes you have to call people multiple times. They call in, so on and so forth. But it is a minimum of 28 phone calls that you will make to your clients throughout the course of a 7-year litigation. Additionally, every time something big happens, I send out a letter informing my clients. The litigation is stuck before the appellate court deciding whether or not our cause of action is a viable cause of action. You send that out, right? Well, you can't say it in those terms, though. What does that mean? Your cause of action isn't viable. Okay, so now you have to take it down a notch and explain that to the clients. And so what I like to do is when I'm drafting a letter for our clients, I take it to someone who has no legal experience whatsoever. After I finish drafting the letter, I will send it off to a friend of mine who lays concrete for a living. And I'll just say, Jim, tell me what you think. And Jim will email me back and he'll say, I don't understand a word of what you wrote. Okay, I need to rewrite the letter, right? Or he'll say, okay, so you're doing this and this and this and this. And yes, Jim, that's exactly what's happening. Thank you. And I can send that letter out to my clients. Again, it's not talking down to them. It's making sure that you put things at a level where it is worth it for them to take 5 minutes of their time to read the letter. And I find that reduces our need for phone calls. I find that reduces the number of phone calls that come in. Obviously, when you send the letters out, a certain population just won't read them. I got a letter. Let me call my attorney and see what this actually says. Same thing, which I know from doing subrogation. You try to explain subrogation to a client. What do you mean I have liens? I paid off my house 20 years ago. I don't have no liens. Okay, let me walk you through this. So, and it's, it's rewarding. It's rewarding to help somebody and to teach somebody in those moments.
So you've been involved in mass torts from all the way the very beginning, intake through settlement management. And I'm curious about how you ensure that smooth transition from the start of a case through resolution, because there's a lot in between that.
There definitely is. And there's 3 factors in managing and making sure that you are prepared when you get to settlement that are really key. You have to have an idea of what your case values might look like and what the issues involved in that case are going to be for what the clients get paid on at the end, right? So from the very beginning, I create what's called a projected injury category list. And this is, we say, well, we know that there's a drug that's causing heart attacks. To the point that there's actually been a recall, which nowadays you very seldomly get the recall before the lawsuits start. But let's say that there's been a recall. There's been a recall. We know that this drug causes heart attacks. And so we're going to put heart attacks on our projected injury category list. Well, what else might be in there? Well, maybe strokes and maybe atrial fibrillation and maybe, this, that, or the other. Well, then you also need to take into account how old was the person when they were injured. Were they 25 years old? Because a 25-year-old having a heart attack is a big difference from a 75-year-old having a heart attack. So when you settle, all of these things are calculated in. These are all objective items that you take into settlement consideration, because our job is to represent individuals in a massive group. So you can't take all of the subjective issues into consideration. Oh, I had pain and suffering, and my pain and suffering was worse than Bob's pain and suffering. Well, I don't know that your pain and suffering was worse than Bob's. There's no way for me to know that. So I have to take into account what are the objective issues. How old were you? What injury did you have? How long did you take the product for? What sort of treatment did you have? Somebody who loses a lung because of a pulmonary embolism is a very different injury than somebody who has a deep vein thrombosis that is cured with blood thinners, right? So under those circumstances, while they are both embolytic events, I have to take into consideration which one does more damage to the overall health. And all of this is just sort of a long-winded way of saying, from the very beginning, figure out what your case is. And then pay attention to what leadership says the case is. Because that's who's going to get to settle their cases. What leadership is acquiring at the beginning is where you're going to get to settle. A good example of this is in a recent litigation, a lot of firms were collecting non-Hodgkin's lymphoma cases. Some people got the idea in their head that multiple myeloma was also probably caused by the product. And they went out and they spent a lot of money getting multiple myeloma cases. Well, leadership had no interest in multiple myeloma cases. They didn't have any multiple myeloma cases. So they didn't hire experts. They didn't get studies. They didn't get, reports. None of that on multiple myeloma. So at the end of the day, multiple myeloma cases couldn't settle. So that's sort of the essence of those first few steps. Then we have to make sure that we keep the data. Collect as much data as you can. If you don't think it matters, get it anyways. If it's anything related to the time frame that they were injured, to the time frame that they were taking the product, to the time frame that they were treated, try to collect as much of that information as you can. Because when the insurance companies come along to try and get their money back through subrogation, and when I'm handing you this information, you need to know what my client was paid for. So that you can go to the insurance company and say, wait. You're claiming this deep vein thrombosis, just staying to our same metaphor here. You're claiming this deep vein thrombosis as part of their injury, but they weren't ever paid for that. They were only paid for the heart attack that they had, which is caused from something very different. It wasn't caused from this deep vein thrombosis. So it allows you guys, in my mind, to better serve our interest and our client's interest, and the less that our clients lose in lien value, then the more that they are able to kind of appreciate what we've done for them throughout the whole process.
So at the end of a case, at resolution, what is the most challenging part of that? Is it the administration? Is it the liens? Is it all the other details that can be involved in wrapping up a mass tort?
I think that's a question that's better answered as, what is your individual task? What is your specialty? My specialty is the psychology of people management, of giving people the opportunity and the understanding of what is happening. It is never my job to convince someone to do something that they don't want to do. So even from the point of when your clients are signing their settlement agreements, well, okay, why am I getting this amount? You get on the phone, you sit down, you treat them like a human being, you have that conversation. When you hire a vendor when you hire a subrogation, a lien settlement agency like Synergy, right? When you're hiring somebody to help you resolve these liens, you make sure that the client understands that there's going to be communication related to that. And then you keep that communication. And you keep collecting data, even after you're done, right? One of the biggest mistakes that I personally have made, and that I've seen made time and time and time again, is we get to the end and we think, okay, we're done. We don't need more data, right? We don't need more information from the client. And so we stop making our phone calls regularly and we stop sending update letters. And now Susan Smith dies and Bobby doesn't call us. And you guys are trying to resolve a lien. And it turns out that Susan's dead, so we can't get the lien resolved because we can't get signatures on HIPAAs or whatever we need. So now we got to go back to Bobby, get Bobby to open an estate. And then Bobby opens an estate, and now Bobby dies, right? And so now we got to go find Tim, and Tim has to open an estate for Bobby. And Susan's money eventually has to go to Bobby's estate before it can go to Tim through Bobby's estate, right? Oh, and God forbid there's a bankruptcy involved in there. So I guess what I find most challenging throughout the course of a litigation is keeping your clients grounded and keeping them in-house. It's very easy for somebody to get back into the wind and just to completely lose them, especially when you're dealing with mental health drugs or drugs related to illegal drug use. Right. When you're dealing with these in particular, it's very easy for your clients to get it back into the wind. And it's very important that you accept that these are an even more vulnerable class that you have to really keep in touch with. Now, in terms of data transfer and data management and all of that, it's hire a damn good paralegal. Hire someone whose whole job is to put their head down and to grind and make sure that your spreadsheets are right when you export from whatever your system is, if it's Litify or Filevine or Lawbase or whoever you may use, right? You're going to export those spreadsheets a lot of times to send them over, and so that people can see, okay, here's the demographic information, here's the clients that we have to resolve, here's how much money they're getting, here's what we have to do on this, here's what we have to do on that. If you have somebody to manage your data properly and you have good communication with your vendors back and forth about your data, then you get a real opportunity there. And I have a friend in the business, Carol Wall, who has done incredible things with data management. In her career, she's an attorney and she does, she's running the data management for one of our mass torts. And the things that she has managed to put together and to help people understand, I really appreciate. And I've taken good lessons from her on that.
One of the things that you focused on in our last conversation was the idea that each client is an individual, not a number. But when it comes to a large scale mass tort, you've got a lot of people involved. So how do you make sure the clients feel valued while still managing hundreds or thousands of cases in an efficient manner?
So this is where I get a little pessimistic sometimes. The first thing that you have to do or the first thing I do, everybody has their own way of doing things, but the first thing I do is I want my clients to understand that while they are important, they are not special. What has happened to you has happened to thousands of other people. And it is important for you as the client to understand that we are here to help you and to help other people as well, and that we are trying to help as many people as we can. Which sounds very almost dismissive of what's happened to them, but there's a way to do it. There's a way to say, Ms. Thomas, I understand what happened. It was terrible. It's terrible what happened to you, and nobody should have to go through that. And you have every right to be upset, right? You have every right, not just upset, to experience righteous anger that this company did what they did to you. But Ms. Thomas, you should experience that not just for yourself. You should experience that for everyone involved, because they did this not just to you, they did this to thousands of people. And my job is to go out here and to make them pay for what they did to you and to thousands of other people, Ms. Thomas. And my goal is to make sure that you and all these other people get some form of closure. I think I've said before, and I may have said it last time, what we do is not justice, it is restitution. If justice existed, the people running these companies would be in prison. If you poison my food, my water, my air, you go to prison. But a corporation is just is only considered a person in terms of their ability to provide funding in campaigns, right? So John Oliver did a piece on this just a week or so ago, talking about how corporations don't ever actually answer for their criminal charges. They just sign away these non-prosecution agreements. And it's a great piece, and everybody should check it out if they get a minute. But it's so we take that. We're here working on behalf of all of you, and B, you should redirect this anger on behalf of everyone. And I find that most clients are very receptive to that idea, and that it helps also when you get to settlement, because everybody thinks that their case is worth a lot more money than unfortunately it often is. But when you get to settlement and you're able to say to a client, we believe that this is a fair, reasonable value based on the number of clients involved nationwide and what we've been able to procure and what this company is worth and so on and so forth. I find that if I've been honest and open and I've explained to them that they're not just protecting themselves and getting something back for themselves, but they're protecting a future generation, what's happened to some companies following some of these lawsuits and what happened to the products that they left out on the market versus what they pulled back and the changes that they made accordingly is ultimately, that's what we do it for. There's a lot of ways to make a lot of money, and this isn't the easiest of them. For me, this is about providing the best service that I know how, and something that I believe in, and something that I believe that I can make the world a somewhat better place.
Speaking of that, final question. You were involved in a mass tort case where the highest national settlement values per client were achieved. And I wanted to ask you about what strategies contributed, in your opinion, most to that success?
Certainly. Proper acquisition of medical records. Getting your medical records early and often. Keeping them updated. Not just, I have enough to file. Every time that something new happens to your client that might be related to the initial injury, you want that medical record. Because at the end, we talked about those objective issues. The objective point values that we're able to assign to clients. Those are hugely important. Separate and apart from those, some clients experience extraordinary injuries. An example of this is there's a young man playing football at a well-known university. And now he's not a first stringer, but he's playing football. He enjoys football. He's 22 years old. He gets cancer from a product that he's exposed to, and the cancer gets into his knee. And he has to have his leg amputated just above the knee to keep it from metastasizing further into his body. That young man exists. That's a real person that, had I not had proper communication, proper follow-up, spent time looking at the medical records, I may not have found that specific extraordinary injury that he suffered. And because of that extraordinary injury, his case value was increased nearly triple what it initially was. And it was not a small number to begin with, but it was nearly tripled in value. Doing that allowed our firm to maximize the value for our clients. Then separately, paying attention to what their liens were going to look like, having an idea ahead of time what liens were going to look like, finding a company, a subrogation company, to review some liens to give us an idea of this is going to be a lot of money that it's going to cost in liens. Getting all of that in place ahead of time, being prepared ahead of time, not just, oh, we'll wait till settlement and then we're going to go run everything to ground, and it's going to take us 2 years to run everything to ground, and we'll get them paid eventually. My clients would have abandoned me if I had done that to them. Even with all the communication, even with all the trust that I had built up, if I had tried to do that to them, they would have abandoned me. Instead, we got one of the highest national settlement averages, if not the highest national settlement average in that case. And we had 99.9% of our clients sign off and accept their settlements. Which is, threshold is 95%. To hit 96, 97, 98 is a huge win. We had one client who didn't agree to their settlement in that case. And we had hundreds of clients in that case, so it was above 99.9%. Can everybody do it that way? I believe that they can. I believe that anybody who wants to do this and is willing to put in the investment and the time and the energy, if they want to do it the right way, I believe that that's the right way. And now I don't do everything right. There's things that everybody gets wrong, but I believe that the best way to do this is to provide a significant award for as many people as significant of an award as you can for as many people as you can. And if you don't do that, have you done your duty to these people who put their trust in you?
Well said. Perfect ending point. So if any of our listeners have questions about anything you talked about today or interested in strategizing with you, what's the best way to get in touch with you?
Sure. So my firm that I work at and that I manage is Rowan, Balaban and Associates. We're out of Denver, Colorado. My email is Andrus, Andrus, at rbatort.com. And also our office phone number is 720-817-4040. anyone has any questions at any time, I'm always happy to answer them.
We'll include all that in the show notes for today's episode. Thank you, Cameron, for your time today, and we'll see everybody on the next episode of Trial Lawyer View.
Thanks, Jason. I really appreciate you having me on again.
Here is another episode of Trial Lawyer View. We hope you enjoyed today's guest and discussion. Tune in to our next episode for more helpful insights from fellow trial lawyers and practice experts. This podcast is brought to you by Synergy. Visit partnerwithsynergy.com to learn more about how Synergy can free your firm to focus on what it does best.